Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Donald Coleman presiding. While court is in session, there will be no talking, no sleeping, no chewing of gum, or reading any material. Please keep your devices on mute until the court addresses you. Thank you.
Thank you, Madam Clerk. This is case number 21-150207. This is Community Financial Credit versus Avondre Washington. The matter is before the court on a petition to show cause. Your appearance for Community Financial Credit, please.
Good morning, Your Honor. John Mueller appearing on behalf of the plaintiff, P number 35413.
Thank you, Mr. Mueller, and good morning to you, sir. The court is looking now for Avondre Washington. If you're on the Zoom, please say something at this time. Avondre Washington. All right, the defendant previously did not appear regarding a subpoena. The court then issued a petition for the defendant to show cause. Does not appear that defendant has appeared at this time. Counsel, your pleasure at this time, sir.
Your Honor, I have an outstanding balance on this judgment of $10,129. I would ask the court to issue a bench warrant and set bond in at least the amount of $10,100.
All right. Given that defendant has not appeared, the court will grant the petition for issuance of a bench warrant. I'll set bond on the bench warrant at $10,000. And I'll sign the order consistent there with counsel. You can email that proposed order to me and I'll get it right back to you. You have the email address, sir?
If you would give it to me, I'd appreciate it.
Great. That would be Carmen is the first name, Carmen, C-A-R-M-E-N dot Banks. Banks is the last name, B-A-N-K-S at 36 districtcourt.org.
Thank you very much. Have a good day.
Thank you. Good day to you, sir.
Bye now.
The court now calls case number 22-188-992. This is Deja Posey versus Gold Key Real Estate. The matter is before the court set on for a motion hearing on today's date. It looks like a motion for reinstatement. Your appearance for the plaintiff in this matter, counsel. Counsel for Deja Posey. All right, do I have counsel for Gold Key on the zone? Just one moment. The last thing I heard regarding this matter is the parties were lightly settled and were going to work this out and that the court should await paperwork. I don't see either party here at this time, and so I'll pass on the matter for the moment. The court now calls case number 22-192529. This is Sterling Security LLC versus Ace Petroleum Incorporated. The matter is before the court after the setting of the scheduling order set on for today's date for a pretrial conference. Your appearance for Sterling Security, please. Do I have anyone on Ace Petroleum? Sterling Security or Ace Petroleum? So these are, Madam Reporter, this particular case has my old Zoom number on it, so we're gonna circle back around.
Okay. All right, Judge.
This, and I'm thinking that might be, well, I know that's the case on this one, so we'll come back to that later in the call. All right, the court now calls case number 11-112946. This is Cash LLC versus Mark King. The matter is before the court set on for a review. Your appearance.
Thank you, Judge. May it please the court. My name is Attorney Richard Grusin. My bar number 35222. I'm the attorney of record for the plaintiff. I'm also here as a respondent on the notice motion to stay garnishment.
Thank you, Counsel, and good morning to you. For Mark King, please, if you're on the Zoom, say something at this time.
Good morning. This is Mrs. King.
Where's Mark King?
My husband passed.
He passed away. I'm sorry to hear that, ma'am. So I think I read something in this regard where you were pointing to passed away sometime possessing cars to be stopped for that reason. Is that correct?
Yes, it's on my state refund.
All right, got it, ma'am. Mr. Rosen?
Judge, may it please court, I confirm that the date of death for Mr. Mark King was December 9th, 2022, according to my review of public records. As you know, Judge, when we were in law school, they were taught that, quote, debts die with the debtor. So therefore, I will, if there is an objection to the tax garnishment, I will stipulate to releasing that particular tax garnishment at this time, close the file.
Very well, I will sign an order, Ms. King, consistent with the reality that your husband is deceased and the plaintiff's counsel in this matter is willing to submit an order that will stop any garnishment regarding this matter. So you'll be receiving something in the mail, an order releasing the garnishment.
All right. Thank you, Your Honor. Will this go to the state as well, or do I need to mail that to the state, or I don't know how this works?
You can, Mr. Rosen, are you going to send a copy to the state, or I think it's going to be on you to make sure the state gets a copy, but the stop of garnishment, that will definitely stop everything, sir?
Yeah, I understand what you're saying, Judge. So what I will do is I'll have my staff do a release of the tax garnishment. That, of course, I have to file it. It goes up to you to release it. And then it'll have the state of Michigan income tax department address so that once the civil clerk enters it, I think the civil clerk mails it out to me and to petitioner and to the state of Michigan.
All right, very well. That's the.
Thank you.
I do wish you well, and thank you. Good day to you now.
Okay. Thank you.
Thanks, Judge.
The court now calls case number SC 222-42568. This is Jacqueline Miller versus Red Baron Enterprises LLC. The matter is before the court on the what I got this set for today. Set for a pretrial conference. All right, do I have Jacqueline Miller on the Zoom? Yeah, you're still on mute. I see you there, ma'am.
Yes.
Good morning, Ms. Miller. All right, for Baron Enterprises, your appearance, please.
Yeah, good morning, Your Honor. Sean Murphy here on behalf of Red Baron Enterprises, P79255, and I have my colleague Robert Gavin here as well.
P72726.
All right, thank you, gentlemen, and good morning to you as well. All
Morning,
right,
Your
so I'm looking at defendant's counter plaintiff's response to motion to amend the complaint. I think I already addressed it. Go ahead and update me, Mr. Murphy.
So the plaintiff, counter defendant, Ms. Miller, had filed a motion to amend the complaint sometime last year. It was never mailed to us. Last time we were before the court, you directed your clerk to mail it to us, and she did. We received it and filed a response to it. We also filed a motion for summary disposition fully against Ms. Miller's complaint, and then in partial summary disposition with respect to both of our claims, Your Honor. We have not received any kind of response to that.
All right, very well. So yeah, let me ask you, I'm seeing your paperwork now, and I'm coming to you in just a moment, Ms. Miller. I'm seeing your paperwork now and understanding that there is a motion to amend the complaint. Does your issues with regard to your motion for summary disposition address issues that might be raised in the amended complaint? I guess I don't want to address the motion for summary disposition if the question of whether or not there's a right to amend the complaint has not been resolved first. Council.
Your Honor, we did address under both circumstances, the motion to amend the complaint sought to essentially attack or sue us for sending a retraction letter, which was required by statute in order to pursue damages in the context of a defamation claim. Ms. Miller seemed to indicate that there was a consumer fairness law that prohibited us from sending that kind of letter. To the extent we could find anything on point, there was the CFRA, but that does not provide a private cause of action. It must be brought by the state attorney general, and it does not impact any kind of lawsuit for defamation. So to the extent that's the act she's trying to move under, Your Honor, we'd ask that the court reject her amendment. It's futile. And in addition, Your Honor, all we did by sending a retraction letter was comply with the statute required to bring the action we did. So to allow her to amend to sue us for that, I'm not sure there's a basis under law for that.
All right, thank you, Council. Ms. Miller, you've indicated to the court that you wanted to amend your complaint in this matter, and I note that in your initial complaint, which was filed in the small claims division of this court, it looks like your claim was in the nature of $1,300. And this has to do with a claim breach of contract, where you hired some person to do ceiling repair, and you're saying the work was not done properly. Is that what this case is about, ma'am?
Yes, initially that's what it was, and Mr. Murphy, he filed to have it moved to civil court in order to represent the client, his client, because they're LLC. So that was the initial complaint.
All right. What is it that you are asking to amend regarding them?
My amend, let me see. My amend complaint was that I wanted to sue them for intimidation, punitive damage, and exacerbation of anxiety and I have anxiety and a disorder. So, I've been really going through it. And I sent you information also from Beaumont Hospital. I know you have a lot of information, but I sent information from my doctor regarding some of the things that I experienced since I've been going through this with them.
All right. So this is by your estimation, this is a $1,300 claim regarding some painting work or patching work that was not done properly. Is that correct, ma'am?
Initially, the contract was for $3,700, and I paid half to have the work done. However, when the painter came out, he did not follow what they told me that they would do. So I was just asking to not necessarily any money, but to not have to pay any more to them because he did not do what he said, And then I also asked the lawyer to give me I think it's called the contract, to describe what they would be doing. And I did not receive that, but it's a lot that you have to hear, outside of that. I don't want to go into anything other than what you had asked me.
All right, yeah. I mean, the fact of the matter is that this is a contractual dispute, and the notion that as a result of a contractual dispute that this turns into a case regarding intentional infliction of emotional distress, that this turns into a case of defamation, et cetera, et cetera. I'm not seeing anything that would give rise to allowing an amendment along those lines in this case.
Wait, let me just say, is that, as I said, there's more to it than what Mr. Murphy is saying. I was actually ridiculed when I went to Red Baron and spoke to the owner. I was ridiculed there along with, they literally made fun of me When all I wanted was for the owner to come out and review the job that had been done because it wasn't what they told me they would do in the steps that they said that they would do it. And I also have where even the attorney said,
Let me stop you.
Okay, go ahead.
The reality of it here is that this is on its face a breach of contract and a very unpleasant breach of contract. And of course, the parties dispute that issue. But this is not a case about an intentional infliction of emotional distress and all of the other nuances that you wish to bring as a part of this case. So I'm going to deny the motion to amend the complaint, because this complaint is about allegations of a breach of contract, and that's what this complaint is going to remain about. So the motion to amend the complaint is denied at this time. All right.
Okay, I understand.
All right, thank you. On the issue of the complaint that alleges that there was some $1,300 that was paid out for a job that was not completed, counsel. Now, I know that there is a counterclaim filed in this. I mean, it seems that what the lady is saying here is she paid some money, she didn't get satisfaction. There was a $3,000 amount that was under the contract that she didn't get total satisfaction. Basically, she said she didn't want to pay the rest of the money. Why can't we get this resolved?
Well, Your Honor, it's not that she doesn't want to pay the rest of the money. She initiated this lawsuit suing for $1,300 because she said she believed that she would get more work done for the money's charged. Our clients did perform half the work. It's a 6-step process to repair a plaster ceiling. They scrape it, oil prime, skim coat it. Then they come back and sand, prime, and paint it. You just can't do all those steps in one day. So it was a 2-day project. They came in, did all the prep work, got it all skim coated, oiled. It was ready to go. I mean, we presented pictures in our motion. We presented an affidavit in our motion. Half this work was done. And the project was teed up for them to come back the next day, sand it down, prime it, and paint it. And that was it. That was the only 3 steps remaining. So for her to come back and assert that she's entitled and only has to pay 15%-ish, I think it works out to be for half the project to be completed. It just doesn't add up. We've presented an affidavit and documentary evidence before the court on our motion. She has not responded to it. It's frankly unopposed at this time.
I would also add, Your Honor, that she paid half the money up front and we did half the work. So in our view, like it's done.
Your Honor.
Let me stop. I don't think there's a stipulation that half the work was done, obviously, and that's one of the concerns here. But I'm wondering why this can't be worked out, actually. But let me deal with it this way. So, ma'am, there is a motion for summary disposition that's been filed in this matter, where the defendants are asking the court to conclude that there is no defense to this, that you have not raised a proper complaint regarding this matter. You have not submitted a written response to that motion. However, I know that you're.
I just received it.
Well, I guess you want to talk and not listen to what I have to say. I mean, what I fundamentally don't understand is how I will give you an opportunity to talk, and yet when I'm talking, you want to interrupt me. That doesn't make a lot of sense to me. If you came to court and the judge didn't give you a chance to talk, I suppose that I would really understand you interrupting to try to get a word in. But my God, everybody gets a chance to talk here, for God's sake. I mean, I don't get this. So let me pass on this. Let me come back because there's a part of this that's wasting other people's time. But I understand that you all are here. I'll come back to you in just a moment. All right, this is case number 19-179-456. This is Michigan Schools and Government versus Antoine Smith, and that is before the court on the filing of objections to a writ of garnishment. This is in regard to General Motors Corporation. Your appearance for Michigan Schools, please.
Good morning, Your Honor. Wesley on behalf of Michigan Schools and Government Credit Union, P number 80307.
Thank you, Counsel, and good morning to you. I'm looking now for Antoine Smith. Antoine Smith, if you are on the
I'm
Zoom,
present.
please. All right, thank you, Mr. Smith. And Mr. Smith, I've looked at your objections to the writ of garnishment. You said that you were objecting because you have an installment order that has been entered and that you're paying on installment. Is that correct, sir?
Well, actually, the wrong paper was entered on my behalf. What I was actually doing was I wanted the garnishment stopped because the original debt was $8,100. I paid them over 85% of that. I just wanted to pay the remaining balance and get it over with. But I've been over time, and I can go into details about how I accrued the
All right, gotcha.
the extra money that they have. I'm at a loss for words right now, but yeah.
Well, no, I understand the interest accrued on
Yeah,
it.
the interest rate. Yeah, the interest rate.
Gotcha. And I see.
So,
I see that they issued a document indicating that you have paid a total of $6,337.25. Mr. Neal, hold on one second. Mr. Neal, what's the balance on this?
The present balance, Your Honor, is $5,041.66.
All right, so that $5,000 something is showing as the balance on this, Mr. Smith, and I'm sure that has to do with the accrual of interest on this particular.
Yeah.
Go ahead, sir.
Yeah. So, what? Hello.
Yeah, I'm sorry. I want to know what did you want to do to try to get this resolved? I don't see any validity to the objections, but I know that this is a wage garnishment. You work for GM, correct?
Yes.
All right. So
okay. Okay.
So, go ahead. I'm listening to you.
Okay. When I originally came across this debt, the amount was $8,100. So I had an agreement with Holtzman Law in the beginning to make monthly payments. At that time, maybe 2 weeks after that, before I was even scheduled to make my first payment, then COVID, the pandemic started. So I called them. I didn't know what was going to happen financially. So I called them. I was off work. I was laid off. We were going down for 2 years. So I contacted Holtzman Law. Okay.
Let me stop. Okay. I'm aware
Sure.
of all of. I'm aware that there was a plan, and then that you were $2,000 behind. I understand that there were special circumstances that may have led to that. The problem right now is that you got an outstanding balance, if you will, in excess of $5,000, and I want to know what do you want to do to try to get that resolved? What are you asking the court to do today?
Well, I really wanted to just settle the difference, settle the original amount. Because, like I said, I paid faithfully I paid actually $6,900 of that debt, not $6,200. I paid $6,900 of that debt, and the only time I've missed payments, Your Honor, is when I was laid off work. Anytime I'm laid off work, I contact Holtzman Law, and I've ran across some mean-spirited people on the phone. I even ran across some people who they made jokes about about my issues and my concerns. So I brought my issues and my concerns to court. So I just really wanted to settle that original amount because I feel like I really do feel like the interest is on there unjustly.
Well, the law allows for the interest to be applied to it. That's the problem here. Let me put the two of you in a breakout room. Let's talk about whether or not they're willing to settle. Make an offer. See if they're willing to settle it for some amount.
Okay. We can do that.
Original judgment amount is whatever it is, and then interest accrues on that. But you might be able to settle out and give you an opportunity in a breakout room to talk with the attorney on the other side, make your pitch, and let's see if this can get resolved. I obviously favor resolutions, particularly where cases have become things where a lot of interest have accrued. I can't force anybody's hand to make that happen, but I will suggest that you good communicator, and let's see if you can come up with, if the two can come up with something that may resolve it. All right, so there's your notification and I will wait on the other side.
Okay. So do I have to push anything?
Yeah,
Push any buttons to get there?
click into the breakout room.
Let's get. How do I get there? I'm just on a cell phone call.
It should have come up on your device, a notification to go into a breakout room. It should have come up on your device.
Okay, let me check my messages. Hold up just a second. I'm not getting anything popping up on my phone.
So you're looking in you're looking in whatever tools you have in regard to Zoom.
Yeah, well, it's a Zoom phone call. It's not the picture message.
All right. So here's
Do I
what
press *6 or?
No, that doesn't do anything there. Yeah, Mr. Neal, it seems like he's having a problem with the breakout room. I'm gonna try one more time with this gentleman. So do you see something now, sir?
No, I don't see anything popping up on my phone at all. I'm going through. I'm going through my text messages. I'm not receiving anything. On the original screen, I'm not seeing anything.
So, Mr. Neal, is there a way that he can reach out to try and make an offer to get this resolved, sir?
Yeah, absolutely, Your Honor. I'd be happy to call him after this hearing. Our position on the motion remains the same. It's not valid, Your Honor. I would request it be denied, but I'm happy to speak with him after the hearing to see if there's a discussion that can be had regarding getting this settled.
Okay.
Yeah, that makes sense to me. So one of the reasons there's not a valid objection, so I'll deny the objections. But it sounds like to me that you're looking for resolve. So I want you to reach out to Mr. Neal and make sure that that he has a number to contact you and talk about this. If for some reason you're not able to get that worked out or get a plan worked out, then file a petition for installment payments. So let me take a look at it to see what might be a good monthly payment for you to pay on this, so you get from a other garnishment. But right now, that motion that you filed, that motion is denied. But again, talk with Mr. Neal, make your offer, and see if they're willing to compromise this, and then you go forward from there. You understand?
Oh, yes, sir. Now, my only other question is, if we don't come to if we don't come to a resolution, can I at least have the garnishment stop?
Well, that's where you would have to. That's where you got to file a petition for installment payments. You can file that with the court, or you can reach an agreement with the other side for payment that will lift the garnishment. I know that lifting that garnishment is a very important issue here, so I'm trying to give you a couple of avenues to search that out. Okay, so the first step is to for you and Mr. Neal to talk to see if you can reach an agreement that ultimately mean that the garnishment will be lifted and you pay this off some kind of way. If for some reason all that falls apart, I'll petition for partial payments with the court right away.
Okay, thank you. So do I call him or?
I'll call you, Mr. Smith, in about 5 minutes, okay?
All right, thank you.
Thank you, Your Honor. You have a good morning.
Good morning to both of you. Just one moment. All right, this is case number 22-182-423. This is Credit Acceptance Corporation versus Amon Harris. The matter is before the court. Looks like set on for objections to a writ of garnishment. Your appearance for credit acceptance, please.
Judge, may it please the court, my name is Attorney Richard Bruson. My bar number 35222. I'm the attorney of record for the plaintiff. I'm also the respondent to defendant's objection to a tax garnishment and defendant's motion for installment payment.
All right, and do I have Amon Harris on the Zoom? Say something if you hear. Amon Harris. All right. That might be on there. Ms. Harris, are you on the Zoom anywhere? All right. I do see that regarding the objections to the writ of that it looks like it says garnishment payments have already been started. That
Yes.
does not an objection. Again, I'm looking for Harris, Armin Harris. If you on the Zoom, say something.
Yes, I'm here. I'm sorry. You had put me in like a room with the wrong lawyer.
That's right. That's likely where I messed up the other time. Okay, got you. All right, good morning to you, ma'am.
Good morning.
All right, I did receive your objection to the writ of garnishment. You said that garnishment payments have already started. That doesn't appear to be an objection to the writ of garnishment, but also you did file a petition for installment payments regarding this matter, and it looks like you're asking to make $75 a month payments under the installment, under a potential installment. Is that correct, ma'am?
Yes, that's correct.
All right, so you know that this garnishment relates to the to your potential income tax return. You understand that?
Yes.
All right. Anything else you want to tell me before I speak to the other side, ma'am?
I have a question. Okay, and when you say it pertains to my income tax return, so will that be garnished too, even if I'm on a payment plan?
Yeah, there are two different types of garnishments, and if your wage is being garnished or something like that, that's a totally a separate and different type of garnishment from a garnishment of like a tax return or a bank account. There are different types of garnishments, and the law allows for both types of garnishments to issue. Are your wages being garnished at this time?
Yes, they are.
Okay, and now I'm seeing that now. That's SKLD Plymouth. That's where you work. Is that true?
Yes, sir.
Okay. All right. Let me hear from Mr. Rusin on this matter, please.
Judge, may I please call Richard Rusin on the record. I believe that defense objection is based on what has been pled in the court record, not sufficient under MCR 3.101 to grant the objections to the garnishment. However, I did see with interest defendant is petitioning the court for a $75 monthly installment payment order. That's all fine and well and good, but I noticed that for the remaining judgment balance due, which I calculate today, of $7,096 at 13% interest, defendant's interest per month is actually $76 a month. So she's not breaking even on getting the judgment paid off vis-a-vis the judgment interest. I would stipulate if it would be available to defendant for her to pay $100 per month, but I'd have to hear from defendant if we can actually move forward with a stipulation that would result in an order with you today.
All right, Ms. Harris, what are your thoughts on the $100 a month? Because the 75 is too low because of the interest accrual on this record now. Talk to me.
So would $85 be better?
I will stipulate to $85.
Okay, and so when that is, I'm sorry, when I'm paying the 85, will my check still be getting garnished as I'm making payments?
No, if you make the voluntary payments, ma'am, your wages will not be garnished. But any garnishment of things like the income tax return, that can still happen. That only happens with the state return. It's not something that can happen with the with federal. You understand? You understand that, ma'am?
I do. I understand. Yes.
All right. So I'll set the payment at $85 a month, ma'am. I will commence that payment. I'll commence that payment on the 10th of March, 2023. You'll make your payment the second Friday of the month, and you got to make sure that you're making it so that the garnishment does not come back in place. The garnishment is suspended. Pending you making the payments. You make the payment, the garnishment stays suspended. You understand, ma'am?
Yes.
So you'll get an order from me in the next few days. And you'll also get the order denying the objections to the writ of garnishment, but you'll get an order for installment payments that I've entered. And that will stop the garnishment or suspend the garnishment. All right. I wish you well, man.
Okay, thank you. I appreciate it. And last question, where do I make the payments at? Do I go to creditacceptance.com and just?
No, you have to pay them too. That's a good question. You have to send them to my office. Frankly, what I recommend, which I recommend to everybody, call my office anytime, Monday through Friday between 8:30 and 7. Talk to my staff. I recommend really calling my office, doing what's called a payment by phone or check by phone. And my office will walk you through how to do that. That way you hang up the phone when you do that check by phone, you know it's done. It shows up on your bank statements next month.
Okay, and then would your information be on the papers that I was sent in the mail for the Zoom information? Like, is that still with that information?
Yeah. Everything you got from the Zoom information is the phone number where you can call my office.
Okay, all right, thank you.
All right, thank you.
All right, thank you. Good day. Good day to both of you.
All right, thank you, Judge.
All right, this is case number 03110273. This is CFC Financial LLC versus Natasha Thompson. The matter is before the court on the filing of objections to a writ of garnishment. Looks like this is regarding the Michigan Department of Treasury. Your appearance for CFC.
Morning, Your Honor. William Hill, P 28608, appearing as coverage counsel today for CFC Financial.
All right, thank you, Mr. Hill. Good morning to you. I'm looking for Ms. Thompson, Natasha Thompson. Say something if you're here, please.
She's muted.
It looks like you're muted, Ms. Thompson.
Yes, Natasha Thompson is here. I'm sorry.
Ms. Thompson, good morning to you, ma'am.
Good morning. Sorry about that.
Not a problem. I see that you filed objections to the writ of garnishment. Says I have no knowledge of the original debt, creditor or debt. That is 20 years old. That would not be a valid objection. If you believe that the judgment is somehow improper, then you would have to file a proper motion, such as a motion to set the judgment aside and that kind of thing. This is a post-judgment proceeding, and so you can't do pre-judgment objections or raise pre-judgment issues to deal with the garnishment. So, for example, if you had filed bankruptcy or something along those lines, then that would be a proper objection. That's why I have a list of things. But pointing out that you have no knowledge of that or anything like that, that's not a valid objection. This case has been going on, of course, in this court since 2003. A judgment was entered in June of 2003 for $2,075, and then that judgment was renewed approximately 10 years later, as is allowed by law, and that's why it's still pending before court even at this time. And it looks like it might be coming up on a expiration. Counsel, talk to me.
I'm sorry, sir.
Oh, I thought you might want to say something about the fact that this was entered in 2013, renewed in 2013, entered in 2003.
Right.
It might be close to the 20-year limit on this. Did you have anything to say about that before I go to Ms. Thompson, sir?
No, Your Honor. I've gone through the register of actions on this thing. This is 20-year-old judgment. It was renewed June 5th, 2013. There have been multiple hearings on this throughout the years regarding objections to garnishment, installment payments, orders for installment payments having been set aside. It is an old judgment. We're showing as of October 2022, there was $705.14 still remaining owing on it at the time of the request for the tax garnishment. I don't think the objections are valid. There was personal service in this case and multiple hearings on this throughout the years.
All right, just one moment. So it looks like the judgment would not expire until sometime in May of this year. That's what it looks like.
Yes, sir.
All right. So yeah, it's still an active judgment, Ms. Thompson. It's near the 20-year mark, but it's still active until either May or June. The judgment's still in place. That's why they can advance the garnishment, because the judgment, it's been a long time, but it hasn't expired yet. Like anything,
Your Honor.
okay, ma'am, I'm listening.
Yes, I'm sorry, Your Honor. Yes. Could I please be informed of what the original debt is, the original debtor, what it was for? Because I do understand that it is quite a while ago. And, you know, I know they say it has been several attempts to correct the debt that was owed. I am not aware, and I did try to reach out for the documents that was sent to me regarding this garnishment to speak with someone so I would know exactly what that debt is from. I'm sorry.
Our file reflects the original creditor was DTE Energy.
All right, there's it, because I said DTE Energy was the original creditor. I don't have any of that in the file. I was just looking, and it was sued in the name of CFC. So DTE Energy was where the debt originally arose from.
That's odd, but like I said, it was 20 years ago. So I'm really unsure. I don't know what address that could have been to be able to even dispute it at this time, to be honest. Do you have an original address that came from? Because I've never had an issue with getting DTE at any address I've ever stayed at. So
20 years later, it wouldn't be particularly relevant to this particular case. The problem is that this has been a judgment since at least 2003, and then it was renewed in 2013. So I mean, you know, there's not a whole lot. There's not a whole lot there.
Yes, I understand. Like I said, because I've never had an issue with getting, you know, at DT in my name or anything at any address I've ever resided at, and I've been on my own for quite a while, so I'm not sure, but I do understand.
Yeah, but a lot of times, of course, and I don't know anything about the case other than the fact that there was judgments entered and so on and so forth. Oftentimes, when the debt is turned over to another agency, and subsequent to that time, do not have a problem with acquiring DTE services or whatever. So I don't know what the history of it is. I just know that there was a judgment that was entered in 2003 that has gone on, and then it was renewed in 2013. I don't find a basic objection to the writ of garnishment. The objection would be denied at this time, and any funds that may be garnered would be released towards paying the judgment. It sounds like the balance is in the nature of some $7 million. Also, this judgment is due to expire at either May or June of this year. So, so you're close to something one way or the other, right? So I wish you well, and you'll get a copy of the order in the mail. Thank you.
Excuse me, am I able to ask a question, Your Honor?
Of course you are.
Thank you so much. Is there, like I said, it's not, if the debt is owed, I'm not trying to get out of whatever it may be that's owed. I just was confused about what it was owed, how it was owed. But is there any way that I can, that he will be willing to set up some type of a settlement with me to get this paid off instead of having my wages garnished?
Are your wages being garnished?
No, they have not yet.
Yeah, maybe the two of you can talk for a moment in breakout room. I think that you may be concerned about something that you don't need to be concerned about at this point, given the nature. But let me put you somewhere where you can maybe talk about just a moment. And signing the order and the order. Mr. Hill, I'm
Do I go ahead and join?
yes.
Okay, thank you, Your Honor.
Thank you. Okay, I'm looking at Mr. Marcus. Why are you here, sir?
Yes, I'm here with opposing counsel on the case of Sterling Security versus Ace Petroleum.
Got it. I did call that earlier. That's 22-192-529. And I held back on that because I think you were in another courtroom or something. Crossed over.
We were currently on a different Zoom. When you click on your name on the Zoom list, it goes to a different one, and we were waiting there for an hour.
Sorry about that. We're trying to get all that corrected. Just for knowledge of the future, my Zoom is 336. I got my courtroom changed. The Zoom number should be the courtroom number, but it's not. So 336 is what the Zoom number is. All right, your appearance in this matter, please.
Yes, thank you, Brian Marcus, on behalf of the plaintiff.
Your P number, if you will, counsel.
Yes, P47125.
All right, thank you for Ace Petroleum, your appearance at this time.
Yes, good morning, Your Honor. Julia Walzak, P85591, appearing on behalf of Nicholas Lefevre. He sends his regards, but he unfortunately could not make it this morning.
Thank you. Thank you. Good morning to you. I set this up on a scheduling order, and then I saw where granted some discovery, and this is the pretrial review date. So somebody updated, where are things at this point?
Yes, we have, Mr. Lefevre and I have talked about this case several times, and we're close to resolving it. We would like, if we could, to adjourn for a short period of time to allow that process to get completed.
Madam Counsel, that makes sense to you?
Yes, that's my understanding as well.
Thank you. So I'll go ahead and grant the adjournment regarding this matter. I'm going to set it over for the 15th of March, 3/15, 23. I'm going to set that at 9:45 a.m.
Very well. Good.
That works pretty well. Thank you.
For review, we'll see you on the next action date. And again, that Zoom is 336.
Yes, thank you, Your Honor.
Thank you very much. Have a good.
Let me check on one other thing. Deja Posey versus Gold Key. All right, so we're back on the record regarding the suffix 2568. And as the court has already determined that I'm not allowing the amendment to the complaint, as it appears to the court that this is in fact a contractual dispute arising out of an agreement regarding repairs and to a ceiling that the plaintiff has complained was not done in a satisfactory manner. I believe that she's asked by way of her complaint to recover some $1,300. Subsequent to that time, the plaintiff, strike that defendant Red Byrne, filed a counter complaint in this matter, alleging damages herein, and had filed a motion for summary disposition as well. On the counterclaim, Ms. Miller, you didn't file any written response to the counterclaim in this matter, did you?
Pardon me?
Did you file any answer to the counterclaim, ma'am?
Yes, I did.
I'm looking for your answer. Counsel, did you receive her answer to the counterclaim?
I did, Your Honor. We did.
So I don't see that, so I'm looking for it. Just give me a moment.
Uh-oh, where did it go?
All right, and I do see now the answer there. Yeah, let's just one moment. So yeah, that seems like a well-joined contractual dispute that the parties have in this matter. What gives regarding the motion for summary disposition, counsel, what you make?
Well, Your Honor, it's more the fact, I mean, half the work was done. She paid for half the work. We presented evidence that this, I mean, the ceiling is primed up, ready to be painted the very next day, which is half the process, the 6-step process. Our workers got 3 of them done. They intended to return the next day or 2 days later, excuse me, to sand it, prime it, and paint it, which is required in the contract. And they were refused the ability to come back and do it. And then adding fuel to the fire here, that Miss Miller, instead of in refusing them to come back, she then goes and posts 2 reviews containing false and defamatory statements, saying she paid $4,000 just to scrape paint or, you know, and repair it, not patch. You said I got a patchwork for $4,000, which is just disingenuous and not true. And then she put another one on nextdoor.com implying that our client preys on the elderly, and that, you know, again, she paid $39,000 or $4,000 for patching work, which is just not true. She, in fact, herself just admitted that. She said she paid $3,700. She only paid half, and the work wasn't complete because our clients were refused the ability to come back and complete the work. So, you know, that's why we put together a C-10 motion. We put an affidavit in there from the operations manager at the company. We got photos showing the before and after. I mean, there was clearly substantial work done to that ceiling. And Your Honor, frankly, it's just, even if she could prevail on a breach, she has no damages. She got work done. She paid $2,000 to have somebody complete the work. She would only had to pay our guys $1,800. So, you know, there's just not much basis for her complaint. The amount of damages she's asserting, $1,300. There's no support for it. So, Your Honor, we'd ask for a motion for summary disposition to be granted with respect to certainly her claim.
All right. So, ma'am, did you get the job finished there? You had someone to finish it. Is that correct?
No, I just have an estimate for what it would cost, what the job would have cost anyway. However, Judge, I want you to go to
I didn't ask you about any of that. Let me ask you about the repairs. How much would it cost to get the job done?
it would have only, for the total thing that they said, it would have been $2,400. I put an estimate in from Focal Point Design. Judge, may I just put?
You paid $1,300. The agreement was to pay something more than that, but you went to somebody else and they told you they would have done the job cheap, correct?
Yes.
Okay, so why didn't you have them come back to finish up the work that they started?
Well, Your Honor, if I can, we dated on May 12, 2022. Mr. Murphy sent something to me saying that Red Baron admits it started the project by patching the ceiling and preparing it for scraping, priming, sanding, and painting. Now, they admit that they only patched the ceiling. They did not scrape, prime, sand, or paint at that time on the 26th. That was dated May 12th to something that they sent me saying, admitting that they did that. However, now, even I forgot the other attorney's name and Mr. Murphy are saying that all they had to do was come back and sand and paint. And that was my issue in the very beginning. I asked them for a, it's called a work order that the painter should have had, detailing the steps to be done. They only patched the ceiling. They never scraped it, primed it, or skim coated, as they told me. I'm not a painter. And so I had focal point design and explained to them. They took a measurement of my living room and told me that for the same steps, it would have been $2,400. But let me preface this. I've had work done by Red Baron several times, and they do amazing work. And this is why I went ahead with $3,700, because I know their work. But when the painter came and only patched it, I was like, well, this isn't what he told me he would do. I asked him, could he just patch it and, you know, scrape the little paint and patched it when he came out to give me the estimate. He said, no, we have to do all this to the entire ceiling for it to be uniform. And also, I just want to mention that Mr. Murphy accused me of pulling a firearm on a company, which I did not do. And I didn't appreciate that, but I know you didn't amend it or anything like that, but they have not been on the up and up. I never received during discovery the income. They claimed that they lost income. I never received anything to prove, which you gave them the order to provide it on our last hearing on December the 14th. And Mr. Murphy also told you that his discovery answers had not been submitted and that he would put them in the mail on the 14th. I show where on even the sheet that he signed, he didn't sign it until December the 20th. So he deliberately deceived the court, just as he's doing now, telling you that the work was 1/3 finished. It was not.
All right, and as you pointed out, ma'am, that you're not a painter, a scraper, or an expert in any of that, correct?
No, I'm not. I'm not an attorney or anything, but I've been working diligently to find a way just to get my ceiling is still in the same condition. Just as they just said, I had someone else to do the work. I did not have anyone else do the work. I only received the estimate.
All right. And,
my ceiling, holidays and everything.
So, ma'am, what happened with the Red Baron coming back to finish the work?
I mistakenly thought that I had went in on a Monday, but I actually called them, kept calling and asking, could Jonathan please come out and look at the work, just examine what was done so that I would know. I didn't understand. As I said, the painter came to my house at 10:18. I have it on my camera. I have vivid security on my camera, and I sent that in also. And they left at 12. Red Baron is saying that the painter was there until 4 o'clock. I was home, so they were not there. The painter and his two guys were not there when I got home at 1 o'clock. And I'm just saying, I begged him. I went to the office crying, and they have a video of my behavior, which they sent to me, what was said and everything, because I was so upset that I would have to pay $3,700 for the painter to patch it, sand it, and paint it. And that's what he was doing. So I said, Jonathan, please come and look, and then explain it to me. I didn't, that's all I wanted was my ceiling fixed, and for him to come and look at it and explain to me what was done and why it was done that way. And he's told me to take my reviews down and he would come out. And that's where I came up with I gave what I thought was honest reviews according to me, with the information that I had at that time.
Are you agreed to pay $3,700 to get this work done?
Yes.
someone got started with it and you were not pleased with what had occurred, and you did not allow any further work until someone would come out and talk to you. Is that the size of what happened here?
Yeah, and that's it, because I wanted to know why he would just patch it when they told me that he would scrape it, prime it, and do a skim coat, which those steps were totally not done. These attorneys are saying that they were done and they weren't. I have in their own word on answer that it wasn't done like that.
All right, thank you, ma'am. Anything further, counsel?
Your Honor, I would just add that before she even came into the office the next day, she had already posted these reviews defaming my client. And you know, she's sitting there saying she paid $4,000 just to patch paint. They never completed the project. They never completed the work. So for her to post these reviews containing false statements, I mean, it's kind of unreal that she's going to claim to be the victim here. And if you read the next door review, we only put the clip in the pleading, but in the attachments, there's all these comments, and those were taken a few days after it was posted. There's probably a lot more now. Just people in the community saying, "Oh, I'll never use Red Baron again. You should have never used them." I mean, her comment and the falsehoods in it caused it was intended to and did cause harm to our client in the community. And it's false. And for her to say that these are truthful reviews, she admitted in discovery they weren't. She said they were exaggerations, hyperbole. She admitted today she didn't pay $4,000. She only paid $1,800. And she's telling people on the internet, I paid $4,000 for patchwork. Well, it's just not true. And it's harming my client's reputation in the community.
All right. Well, I've heard enough as it relates to this matter. Listen, it sounds like to me, with all of the information that's been brought to me, is that in a subsequent communication with another entity regarding the repairs, that defendant determined, that's right, that the plaintiff in this matter determined that she could get the work done and completed at or less than the price that was agreed upon with Red Baron. She obviously elected not to go with Red Baron any further. Her agreement was to pay $3,700. She put $1,300 down, and then she decided that she didn't want to pay any more money until someone came out and did a further inspection. That was not an inspection or a request that was secondary to having some professional agency come out and say that there was something wrong with the workmanship, nor did the person or the party that she called out to review this and estimate it, nor did they point out anything that was wrong with the workmanship. They pointed out simply what the cost that they would charge to do the complete job, and did not point out anything that was defective about the workmanship. This is the kind of problem that is run into oftentimes with individuals who hire companies to do work because those companies are professional and experts at doing that. Ms. Miller had a history with Red Baron and trusted that they would be able to do the job well. In this instance, she second guessed them after the first activities at the premises and decided that she no longer wanted to go forward in the contractual agreement. The law really doesn't allow her to back out of the contract in that way. But at the end of the day, there really isn't any damage here. The fact of the matter is that she can get the performance that she wanted in the very beginning for $3,700 or less. That's what she was willing to pay. She can get that performance for that amount, and perhaps she can do it for less. The company that she went to said they would do the whole thing for $2,400. Well, some of the work has already been done. And if they'll do it for $2,400, then they'll do it for $2,400. Whatever it is, they said they'll do the whole thing for $2,400. If they do it for $2,400 and she's paid $1,300 already, that's $3,700. That's what she agreed to pay from the very outset. That's what the contract was. I don't see any damage in that regard. And so the motion for summary disposition, if I take the evidence in the light most favorable to the non-moving and the light most favorable to Ms. Miller regarding whether or not she has suffered economic damage by virtue of the fact that she may have to pay another company $2,400 to repair the condition that would bring her total payment for repair of the roof to $3,700, which is the amount that she agreed to pay. If I take that in the light most favorable to her and assume all facts in it in her direction. There is nothing in this case that shows that she suffered economic damage by the activities that were engaged in by Redburn Enterprise, at least as it relates to looking at the four corners of the contractual agreement. She agrees that she can have that ceiling repaired for $3,700, and that's what she agreed to in the very beginning that she would pay for. There's just no damage there. Then, as it relates to that portion of the motion for summary disposition that seeks recovery on a claim of damages to business reputation and what have you, so on and so forth, certainly there is not sufficient evidence, even viewed in the light most favorable to the non-movement, if you will. There's not enough here for the court to grant a motion for summary disposition on the counterclaim in that regard. So the motion for summary disposition in regard to the counterclaim is denied. With regard to the complaint, the motion for summary disposition will be granted, and the case will be dismissed in that regard. The counterclaim is dismissed as well. That is my answer. I wish both sides were okay.
Your Honor, I'm sorry, I don't understand what's going on.
The case is dismissed. The court found no cause of action for you and no cause of action for the other side on their counterclaim. The reason I've set forth on the record, there's no damage here. They have to be able to establish that you would be damaged by something that was done, and by your own account, you can get that job finished for $3,700 or less. That's what you agreed to, whether it's with Redburn or whether it's with some other agency. You agreed that
okay,
get $3,700, maybe less, and so it seems that there was a breakdown in a contractual agreement that the parties had, and perhaps it does not seem to me that that agreement could be substantially enforced by either party at this point. And so my finding is simply that the $1,300 was paid to get it started, and the balance of $2,400, if that's what has to be paid, will bring it to $3,700. That's what the agreement was. No damages on either side in regard to this matter. And I am not making an ultimate determination on some of the issues that might pertain to these parties. If you decide that you want to sue in another setting for some stuff, that's up to you. But at least what is in front of me, the motion for summary disposition is granted on the complaint, and motion for summary disposition on the counterclaims. Good day.
okay. Thank you.
Your Honor, just to clarify one point, we just asked for partial summary disposition on our other claims that there were false statements made with the intention of harming our reputation. We intended to put forth evidence in a trial setting regarding our damages. We didn't present evidence of damages at this time. We know that that's a question of fact. So, Your Honor, we would like the opportunity to continue on that front, or at least have an order directing Ms. Miller to take down these reviews. As she's admitted in discovery, they do contain false statements.
I am going to dismiss the matter as I've indicated. I will say to Ms. Miller that she faced the prospect that maybe you file a lawsuit in circuit court alleging damages to the business economics and what have you arising out of statements that might in fact be false statements. And to the extent that you advance that cause, then maybe you can proceed on that in circuit court. So I can't be anybody's attorney, and I can't really issue a broad sweeping order. I do suggest that where this case shows that there's really not any damages that occurred as it relates to the dealings between the parties, that as it relates to anything that might be out there that may have a tendency to damage business that may not be truthful, that could lead to a cause of action that could result in someone receiving a judgment, $25,000, $30,000, $50,000 for stuff like that. So that's not to scare anybody or anything else, because I'm not in that business either. But it seems here that after these parties had dealt with each other on several occasions before, great work, that it didn't work out well here, and that emotions ran high, folks got frustrated, and then information started being put out on various ratings and social media, whatever. I suggest that be taken down. That's all I can do is suggest it. If it's not, then you have the right to bring a cause of action in that regard. I just think that the context of this case and how this case is styled, that it cannot be sustained at this time. That is not res judicata as relates to any claim that might be brought in the future.
We did bring a claim for defamation, Your Honor.
Well, I'm dismissing it on the motion that you brought and on the court's finding that this is a contractual relationship, that the defamation claim is not properly before this court.
Understood.
That does not res judicata this any defamation claim. If you wish to bring it, in a separate suit or bring it elsewhere, you certainly do that. I've severed it from this case.
Understood.
All right, I wish you well. Good day to both sides.
Your Honor, may I ask you a question?
Yeah, quickly, ma'am.
With discovery and with you telling them that they should have, you verbally told him that he was supposed to supply me with the damages that their income was lost. I never got that with the discovery. And I know you dismissed everything. However, I was just wondering, how do I get that info? I mean, weren't they required to send it to me?
If they sue you in the future
Mm-hmm.
for having that stuff out there, which they can do.
Okay, I got that.
If they sue you in the future, that's a part of their claim that they'll have to prove.
Okay.
And one last thing, Your Honor, just that just to make sure that we're good going forward is just, could you dismiss the defamation claim without prejudice, that we can bring it again in circuit court?
That's the intent. That is the intent that the court had in mind, that it would be dismissed with prejudice because an alternate finding has not been made on that. I just severed it from this particular case because I don't think that this is a proper setting in which to bring that particular claim. So it's severed and is dismissed without prejudice. And that's why I was telling you that if they desire to bring some type of defamation or whatever, then they bring that and then they'd have to present the appropriate proof in the right setting. And those things are kind of dangerous when it comes to business practices because, let me go off the record